If provided they finish off, we are not going to give them any other day now, more than this. Half an hour to him, half an hour to him, and rest to you. Hmm? All right. You will finish off in half an hour. So can we ask them to come at 3? How much time will you take, Mr. So you can think of I am coming at around 3:30. Till 3, from 3:30 till 4:30, we'll take up the regular matters. Or should we adjourn the matters? Only keep your matters. No. Any urgent matter? We have already taken up urgent matters before. Then you can all, yes. All right. The rest of the board stands discharged.
The subsequent recruitment of sub-inspector, was the issue of age relaxation. Your lordships granted the status.
That is not connected with
no,
this.
The Honorable Supreme Court, they have requested
In that
this.
case, they have requested. We will see
No,
that
this case they have requested.
in that case, they have requested for this case.
Yes, that they may be heard together. That's fine.
What is that order of 13 November, which you challenged?
It was stay on the entire order, your lordships. I don't have the copy.
You have that order with you? The order passed by the division bench.
Yes, your lordship. It was admitted and the operation of the
DB appeal breaking. Let you start.
Item number 3 से only
Yes.
Please.
You are in which appeal? Vikram.
yeah.
From last day, for the day, I committed for losses. He has this process of committing that the learning individual has given undue importance in the fact that instead of one single day, 3 days were fixed for the examination. And also, that I had completed that part of it. And I had also shown from the order that he also pays undue importance to the fact that 10 minutes extra were given in this examination for entry. And that led to probably adding the lordships find that as far as I have shown to the lordship, that it was a conscious decision taken with the meeting of the Home Department in all, as well as the
Stated that was COVID time.
and that was and not only that, the lordships find that in the additional affidavit filed in Amarjit's case, lordships, the in Amarjit's case, lordships at page 634, my lord, in the subsequent all subsequent examinations, not only it's not that it is in this particular case of SIs that entry of 10 minutes was allowed. In all the examinations of the conducted by the RPSC, including RAS examinations, which was 35 days later.
All right.
The kindly see at page 634, I have included the instructions to the candidates in the RAS examination at page 634.
All right, taken.
It says, my lord, pariksha
You can come on the next point.
point. 10 minutes तक.
You can come on the next point.
That is. So, as a matter of fact, like this, in any manner, your lordship, coming 10 minutes late or postponing or rather increasing the number of days for holding the examination does not in any manner help persons to cheat for the simple reason that if had it been a single day examination, there would have been increased chances of cheating. Because then in one single day, my lord, one action itself would have been sufficient. Here, for 6 different papers spread over 3 days, the action would have to be repeated for cheating. So as a matter of fact, my lord, spreading the examination for 3 days would reduce your lordship the chances of a paper leak. Because then in every paper, the same motive would have to be adopted, which would be far more difficult for even for gangs to operate.
Oh.
And the decision was taken by the state government, not the RPSC and the RPSC level. So therefore, the influence that has been drawn by the learned in this regard is incorrect. He has taken these small aspects of holding the examination as being very crucial to the integrity of the examination itself.
Okay.
Now, when such a large examination is being held, there are bound to be certain laws. He has said that nodal officer, what it was left to the nodal officer, obviously it has to be left to somebody to take care of everything. That does not allow to undermine the examination integrity. Apart from this, a lot to find.
Yes.
That the report that was submitted to the entire judgment is based only on the first SIT. But the second SIT report was far more detailed. Because the first SIT report was only based, as I submitted to your lordship on the last day, that at that point of time, the state government, looking to the fact that FIRs had been lost, a lot of newspaper reports had been made, had given the task to the SIT to give a report as to how it can be cancelled. So it was with that objective in mind. Later on, when the investigations took place, and all the people at that point of time only in respect of 2 FIRs charges had been filed, and that was limiting the lot to singular instances, where say for example in Bharti, a person was found with a Bluetooth device, one single person, FIR was lost, that was investigated. The learned single judge has a lot of justice from that investigation, which correlated to one person. In the investigation, it was revealed that by way of they transmitted the answer sheet. But how many people could be arrested on that basis? Only there were only two persons who had been arrested who had used up till now. The details the lottery needs to see of the persons who had been arrested for different. The lottery find in the second SIT report.
We don't have that second SIT.
It is submitted to the lottery.
Was given in a sealed cover. The decision of the state is on record, but the second SIT report, it was given in a sealed cover.
It was given in a sealed cover, but the gist is there. But nevertheless, a lot of kindly
SIT report is sealed cover. Who had given that, this field cover?
By the AG, by the learned AG, sir.
It was given in a CD cover to the honorable court. And the gist of it was
Only the
given in the affidavit. But the entire SIT report, or second SIT report was available to the landed female. He fails to consider that. And the entire decision is given only on the basis of the first SIT report.
Was it returned back to the AD?
That I will.
Second SIT
It
report.
was submitted in field cover to the
I think till the writing of the judgment, I am not sure. It was,
was there.
but the learned singular notes that the entire report is in favor of the petition, except the part of the conclusion where they say that possibly in future we will arrest more persons and segregate.
How could that be? The findings are there.
And sir, if I may apprise your call, the opinion
Since
of,
we don't have that report, please don't refer to it. Has it been referred in the order?
This is there, this has been referred, the affidavit is there. The state affidavit is there.
In your petition, or this Kailash?
No, in the Kailash petition.
देखो भैया affidavit कौन सा है? Could you give us the date of that affidavit?
It's 180.
date of affidavit is 1/7/2025.
Additional affidavit on behalf of respondent,
23.
1879.
Yes, sir. I think not to the affidavit first one. Para 4.
Yes.
Para 4. At 1880.
One,
1880.
para,
4. Refer to the order passed by the Honorable High Court by the order dated 21st February 25 and directed the state respondent taken association the matter at the competent level and to authorize the Honorable Court. And in pursuant to the direction issued by the Honorable the Committee of Ministers examined the matter and got reports from the SIT Home Department, Director of Economics and Statistics and the Department of Personnel. Meeting of the Committee of Ministers was conducted on 28th June 2025. The meeting committee report dated 25/6/2025 for the chairman SIT. Report dated 27/6/2025 for the Home Department. The report dated 27/6/25 of the Department of Economics and Statistics, and the report dated 27/6/25 of the Department of Personnel. The chairman SIT submitted the report dated 25/6 to the committee in the status of the industry. Made so far in years of the candidate, the arrest made so far in sub-inspector directed to the exam of not only the candidate but also the other executive matter. That the conclusive part of the report dated 25/6/25 is introduced here. वर्तमान में जारी जांच पड़ताल में प्राप्त लाभों के आधार पर प्रमुख गिरफ्तारियां की जा सकती हैं। अब दो आरोपी फरार हैं, यदि उन्हें शीघ्र गिरफ्तार कर पूछताछ की जाए तो उनके माध्यम से आगे कुछ और भी गिरफ्तारियां कर संभावित दोषियों को निर्दोषों के सजा करने की कार्रवाई लगभग पूर्ण हो जाएगी। हमारी ओर से जांच को पूरी तेजी और प्राथमिकता से आगे बढ़ाया जा रहा है ताकि बड़ी दोषियों की ठोस कार्रवाई की जा सके। नॉट दैट कुछ गिरफ्तारियां हो जाती है, हमारी तरफ से उनको पृथक करने की टेंटेड और अनटेंटेड पृथक करने की कार्रवाई लगभग पूर्ण हो जाएगी। विल बी कंप्लीटेड। Then the lot of speak. Next paragraph follow. In the report that is 25/6/2025 of the SIT, certain information given may be exposed in public domain, which may adversely affect the investigation. Therefore, the report of the SIT shall be placed on the report is sealed. if the needs were right. They're not para 13, the lottery kind of reason. The committee of ministers and its meeting, which could give 625 and consider the report referred above, arrived at the conclusion that the strong evidence is eligible for inquiry and validity for circuit arrest. The state government has taken action of removing agent candidate from service. The committee also analyzed that the investigation for candidate is same and the progress investigation in arresting the tainted candidate, therefore it's sought to segregate the tainted and untainted candidate. The committee also found that the spatial distribution of the candidates in the recruitment of 2010, 2015 and 2021 is almost similar. Therefore, there is no reflection of any abnormal selection from certain districts of Rajasthan. The committee also found that large number of candidates selected the present recruitment process were previously working in other government services and only 2 of them have been placed. In these circumstances, it would be premature to cancel the entire recruitment process, and it will also cause industry and teaching candidates. Then the lottery referred to the quoted portion has been 187. That is the recommendation of the ministers. Is refusal to the SI के द्वारा अनुसंधान को आगे बढ़ाया जाए और बड़ी तरीके से दैनिक समझ अभ्यर्थियों को गिरफ्तार कर प्रभावित कार्यवाही की जाए। चिन्हित आक्षेपित अभ्यर्थियों की सेवा समाप्त की जाए एवं उन्हें भविष्य में राष्ट्रीय भर्ती परीक्षाओं से निवार किया जाए। पुलिस उप निरीक्षक राष्ट्रीय कमांडर भर्ती परीक्षा 2021 को रद्द करने का निर्णय इस समय लेना अपनी और होगा। इस भर्ती प्रक्रिया में शामिल अभ्यर्थियों के हितों की रक्षा करने हेतु आगामी नवीन भर्ती परीक्षा में पर्याप्त संख्या में पद विज्ञापित की जाए। I may inform you lot that at that point of time, like 61% had been eligible. Over a period of time, up till now, 3 more have been eligible. So that is 64. Now, one more aspect I to find that all the cases in which the architecture to be verified, if they have been filed, including the charge sheets under the by the they have all been filed after the first SIT report. So, at the time when the first SIT gave its recommendations, except for the charge sheets, there were no other charge sheets available in them. The rest all are substituted. And the lottery kindly consider the annexures to these reports, so of course have been dealt with. Lottery find it 1891 mark. How they have analyzed it. Because the collector.
Yes.
And Manchika case, the Honorable Supreme Court took again statistical reports and got them analyzed by the IIT. A similar exercise can easily be done in the present case. Of course, we have endeavored to do it a lot. On the basis that how they did it in Manchika's case, similar effort we have also done, and clearly shows that there are no abnormalities, except of course due to the fact that in such a large examination, there are bound to be stray incidents, not cheating. Look at page 1891. निरीक्षक, पुलिस, प्लाटून कमांडर, भर्ती परीक्षा व जिम्मेवार चयनित अभ्यर्थियों के चयन कोई अप्रत्याशित वृद्धि या कमी अथवा नहीं है, इस दृष्टि से निम्नानुसार तुलनात्मक अध्ययन किया गया है। वर्ष 2021 की परीक्षा में चयनित अभ्यर्थियों के प्रतिशत के आधार पर टॉप 10 जिलों का गत 2 परीक्षाओं वर्ष 2016 व 2010 के चयनित अभ्यर्थियों के प्रतिशत के आधार पर टॉप 10 जिलों से तुलना। It follows the same pattern. The selections made in the earlier examinations of 2010 and 2016 are more or less similar to the pattern of selection from district wise. Then वर्ष 2021 की परीक्षा में चयनित अभ्यर्थियों के प्रतिशत के आधार पर टॉप 10 जिलों का वर्ष 2016 व 2010 की परीक्षा में चयनित अभ्यर्थियों के औसत प्रतिशत के आधार पर टॉप 10 जिलों में प्रतिशत चुनना। वर्ष 2021 परीक्षा में चयनित अभ्यर्थियों के प्रतिशत के आधार पर बॉटम 10 जिलों का गत 2 परीक्षाओं वर्ष 2016 में चयनित अभ्यर्थियों के प्रतिशत के आधार पर बॉटम 10 जिलों से चुनना। वर्ष 2021 में चयनित अभ्यर्थियों के जिलेवार चयनित प्रतिशत का गत 2 परीक्षाओं से सहसंबंध गुणांक के आधार पर तथा तीनों वर्षों में जिलेवार चयनित प्रतिशत का विश्लेषण। All has been done. Though of course the entire detail work, because each of the departments has done, not only the department of statistics, the department of home, department of personnel, all have done it here also. And each of that, because it's a bulky document, so it was submitted in seal cover before this honorable court. The gist has been given here. And it has been found to be. Now, Lord Smith, see, at page 1896, my lord. District share in total selections in 2021, 2016, and 2010. Has there been an abnormality allowed to district could have been reflected? Say, for example, in Bikaner and Pali, FIRs were there. There is an FIR in Nalwar and in Jaipur.
Yeah.
Now, Lord Smith, it follows the same pattern not as earlier. At page 1896, you ought to find.
All right.
Lord, see the graph. This was the pattern you ought to 3 lines you ought to find. Lord, in each. That is 2010, 2015, and 2021. One 897 gives discussed.
That AG had taken us.
Yes, and 1898 is the chart of the district-wise selection.
Yes.
In these 3 selections, 10, 16, and 2021. Shows absolutely a similarity in the thing.
Yeah.
At this point of time, the Lord may consider the case of Vanshika Yadav. At paragraph 55 and 56 in the English compilation, the Lord will find page 479 to 504. Lot में see paragraph 56. 56 for a lot. It would be.
Sarah?
56 mark.
Yes.
IIT Madras then analyzed the data. The affidavit states that it was done with the help of Python for data processing. For PostgreSQL for data storage, database for analysis after receiving the data information from material. The expected summary of the report prepared by IIT across the mass distribution follows the bell-shaped curve that is witnessed in any large-scale examination indicating no abnormality. Can I just give you this? The bell curve, the lordship find this bell curve not in the present examination. We have made an effort to respect all the selected candidates' marks as adopted therein. Lordship find from the lowest it starts with if there was mass sitting a lot. This broad length of the line, at we start just about 1 way. That would have been very sharp up ahead. Because then, if there is a mass sitting, then more or less everybody has the papers. Then the bell starts immediately.
Yes.
And what we see here, it's again as a matter of fact, higher percentage, it's falling suddenly. Notice this. On an average, more or less, the selected candidates are in a bell-shaped curve. And if you also see the right-hand side, it's falling suddenly. So then, if there would have been mass sitting, it would not have fallen suddenly. It would have increased a lot towards the end. That interpretation of the graph is not fine. Analysis of the distribution of marks, total candidate grade 38, mean score is 306.38, standard deviation is 39.99, maximum score is 385.71, minimum score is 176.20. Difference between the minimum and maximum, had there been marks sitting a lot, it would be much more. Interpret the bell curve above shows that the marks of the mathematical candidates are centered around the average 306.38. As the marks become very low or very high, the number of people decreases, which is the characteristic of a normal distribution. Looking at this bell curve, the next paper, if you consider the bell curve in traditional and also the patient and time of patient, there are no clear indications of paper for regularity. Normal distribution on the next paper. It looks like an ideal bell shape. This means the mark of both students, the crowd, are around the average 306, and the number of students increases as we move toward very high or very low marks. This is the natural pattern for any fair exam.
This is only for regard to the written examination part.
Regard to written examination part.
All right.
The written exam. The entire application is only of the written examination.
Well, that we know.
Yes, because paper needs dummy candidate. Both are related only to the written examination part. There is no part because here again the lordship find. Well, in the cases in which the Honorable Supreme Court has cancelled the examinations, your lordship find them as there were single examinations. There were some written examinations or maybe only interviews. Or only interviews. But here it's not the examination is staggered in 3 stages. The written examination, then the physical efficiency test, and then the interview. So the entire allegation is a lot. 50% is made through the FIR and the SOP report relation only to the written examination. Then coming back to Vanshika Yadav case, B. City-wise and center-wise analysis was done for 2 years, 2023 and 2024. To find out there are any abnormal indications, the analysis carried out for the top 1.4 lakh ranks, given that the total number of cases across the country around 1.1 lakh. But this the home department has done and the statistics department has done. all district-wise in relation to the earlier examinations of 10, 2015 and 2021. And they found no abnormality. They said that this is absolutely similar, district-wise allocations or selection. Then, see, this analysis is granular enough to indicate any abnormality at a large number of students according to high ranks of 5% due to malpractice or a student from a particular exam center or city was benefited. The analysis shows that there is neither any indication of best math malpractice nor a localized set of candidates benefiting leading to abnormal score. There is an overall increase in marks obtained by students, especially in the range of 550 to 750 across region and sector, which is actively qualified that that's a particular case that here there is no abnormal increase also of marks here. So he also is ultimately does not reflect. As a matter of fact, in the selection, only the increase that has been noticed is in relation to SC/ST candidates. In the past two selection this time SC/ST candidates are more. About 80 candidates have been selected from scheduled class 2 to 800. That is because the seats of SC/ST in the tribal areas specifically they have been increased. So that was the increase of SC/ST. In the normal course, if we see that people come from that cadre of society about then Lord, paragraph 76. Sorry, 94. 74 of Vanshika Yadav's case. There are some four. Data analysis of results has long been an accepted method of discerning the extent to which an examination has been initiated. In examination board, they would consider the validity to cancel a secondary examination conducted at a particular center in Bihar due to the adoption of unfair means by the student. At the center in which malpractice appeared to have taken place, the percentage of students examined to about 80%. The staff compared the average percentage of successful candidates average percentage of 50%. This board also considered the percentage subject-wise for 30 subjects. The marks detailed in the judgment indicate that the candidates performed extremely well in all subjects, leading the court to hold that the figures speak for themselves. Despite this conclusion, the court called for some answers rejected and respected them. Its conclusion, though, based on the data, that the exam was initiated was sometimes by the answer showed that there was market agreement in the answer. Data analysis is a useful tool in the endeavor to detect malpractice. Now, if we see this, the data placed before us on the percentage of success from different centers did not account for fees, which would be allocated on the data of reservation, which would start with price and the back of the intersection, but such which to account for the figure of 108,000 would almost be half, and the data analysis alone side. So here is a lot. Then similar data for Patna for 2024 is getting calculated bills. So all this data has been analyzed. And then 79, paragraph 79. The conclusion from the above figures it becomes clear that there are no abnormalities in the results for 2024 when comparing the results of the past 2 years. The report of the director was also supported the conclusion of the report. The report stated that there were no abnormal indications of results for this year when compared to previous year. It also stated that analysis showed that there is neither an indication of mass malpractice nor a localized set of candidates being benefited leading to abnormal score. Hence, an analysis of the results does not lend support to the case of pushing cancellation of the exam. The leak of the paper does not appear to be widespread or systemic. It appears to be restricted to isolated incidents, some things which have been identified by the police or are in the process of being identified by the CBI. Right, here is also a lot of find that while in identifying the reliance of the first society report, which had no conclusions, no investigation till then, only a hypothetical assumption on the basis of the FIR.
Okay.
Here, the second SIT report is based on a total analysis of the statistical. In an effort, to segregate the tainted from the untainted and considering the investigation which has extensive investigation which has taken place up till now.
Yeah.
But here, of course, as if we see the total investigation part, the lot will find. Like the total arrests that have been made, my lord.
You just pointed out 64 of them.
Yes, sir. Out of that, my lord, in relation to paper leak, my lord, the allegation of paper leak, 40 people have been arrested. Then in relation to the use of Bluetooth, my lord, in the examination center, 5 persons have been arrested.
All right.
When this report was submitted, my lord, dummy candidates were 15. When the report was submitted to Sanjay.
Yes.
And one stray incident of one sitting at one particular center, only one person. 61 had been arrested since then. Now 3 more candidates have been arrested. They have been arrested only in the category of dummy candidates. Now look, because as far as the investigation of these dummy candidates is concerned, that has been done on a very scientific level by the HOD. That their fingerprints have been taken, photographs have been taken, the learning is just say that photographs in the form got so blurred that they could not be identified at one point. One was huge straight incident of that cases may have been there. That does not generalize it. So that if we see the entire analysis, the lot will find that after so much of effort by the investigating agency, if only 64 of the total more than 890 candidates who had been initially selected have been found to be taken. Would it be said to be of such a pervasive nature that the match sitting at such a level that the entire examination has to be cancelled? Especially in respect of the RPSC where, as the Advocate General pointed out to the from this the statistics, that people had come from various services. That data is available. But out of these 850% selected candidates, 421 of them subsequently passed the RS examination also. This detail has been given to see at page 619 of the additional affidavit filed by the petitioner in Amarsit Hill. 400 out of the selected candidates, 421 subsequently passed the RS examination because more or less on the same pattern of the general knowledge test was more or less on the same. Or maybe even tougher. So that was possible. These statistics are an established way of finding out whether there has been mass cheating or not. If so many selected candidates would succeed elsewhere, It would be a lot of, in my own submission, absolute guesswork for conjectural and surmise based on surmises to infer that there will be mark cheating. Please, Lordship, fine.
That means it can, this is a method of inference, which you say is being adopted.
Yes, sir. It's only about conjectural. It's totally conjectural and only
Or
not on because if it was without, then the learned single ought to have relied upon the second SIT report, which was more or the conclusive and based on statistical analysis. And after more than 1 year of the investigation, I will take place. But that is ignored, and only on the first SIT, we cancel the exam.
all right.
Then followed the lot of time. But time and again, the case of Vaisakhi Bhattacharya, West Bengal case was referred. I take a lot of certain paragraphs of that. As to what was the nature of that particular case. In all other cases, the lot of where petitions have not been, the Honorable Supreme Court has revised its three principles a lot. If those three principles are considered in this case also, then it is established that there is no pervasive, their allegation cannot be said to be so pervasive as to cancel the entire examination. What happened in that Bengal case, a lot of candidates see at page 435 of the compilation, para 20. The entire case, the lot of was not of cheating as such, but manipulation of marks and OMR sheets. Not of paper leak. Para 20 is considered. Illegality in the selection process. In our opinion, it is obscure. In our opinion, this is a case wherein the entire selection process has shifted and tainted beyond resolution. Manipulations and fraud on a large scale coupled with the attempted cover up have dented the selection process beyond repair and partial exemption. The credibility and legitimacy of selection are limited. The High Court has referred to the reality to include judgment as under. SSC had appointed an engineer and employed SCA for the purpose of scanning and evaluating the OMR sheets. But not question of paper leak at all. Evaluation of OMR sheets by a closed door tender process in violation of Article 14. So the selection, it was based on the examination of OMR sheets by an agency. Then it was verified. Such agency had engaged another agency in the data scan tech to scan the OMR sheets. Although scanning was done at the office premises of SSC, it is claimed by SSC that SSC has never engaged data scan tech to scan the OMR sheets or authorized SSC NYSC to engage data scan tech or any other agency. SSC had destroyed.
Mr. Muthukumal, this was all read to us.
No, I don't think so.
Yes. We mark it.
All right. So the entire allegation will not be linked to that.
Yes.
That the OMR sheets were not produced, they were destroyed. So there was bumbling in the scanning of the OMR sheets, and subsequently the OMR sheets were not even produced when the allegation was made, or rather the submission was made that they had been destroyed. And then the selections were made beyond the panel of selected candidates. After the expiry of the panel, the selections were made. Then they said that the total beneficiaries of illegalities are yet to be identified and rendered improbable given the stand of SSC. So that could obviously, because the stand was that they are destroying the OMR sheet, so it is not possible at all to see whether who had benefited and who had not benefited. So these were the type of allegations. So therefore they said that this is such a case where it is impossible to now find out whether it can be done or not. Congress, in contrast, if we see the order passed by the elected single judge, and 42 will not be considered in this judgment. Para 23 or Article first point, WSSC has been candid enough to admit rank jumping, out of panel appointment, candidates were not recommended by WSSC were appointed by the board, manipulation of OMR scores. However, there is a discrepancy both in the number of candidates and the corresponding percentage. Then para 28, he may have accepted this important word. He may have accepted the argument of if WSSC had the original physical OMR sheets or the mirror copy of the OMR sheets. However, the WSSC accepts that they do not have the physical OMR sheets as they were destroyed in terms of Rule 21 of Class 9 and 10 and Class 11 and 12, where rules which require retention of OMR sheets for only 1 year. Para 42 conclusion, in spite of the factual background and the credible evidence indicating irregularities, WSSC immediately took try to cover up the actions and illegalities. The cover-up itself has made the verification and ascertaining more difficult or rather impossible, given the scale of camouflage and dredging of them at each stage. They are convinced that the entire selection process was intentionally compromised due to the illegality. In our case, a lot of used to see the actual and the recommendations of the SIT clearly say that it is possible we are doing it and it is at the completion stage. And subsequent actions further show that only 3% have further been formed after further detailed investigation. If we see the order of the learning single judge method in this regard, the learning single judge in its conclusion says otherwise. He takes only this matter that earlier also examinations have been cancelled by the state government, so here also it should be cancelled. The learning single judge says that here it will be a very time consuming affair and probably not possible also to segregate. But from where does the learning single judge say that it will be a very time consuming affair and it will not be possible to segregate when the SIT now categorically says that it is possible and we are doing it in the final stage. So if on that basis the learning single judge says that the entire examination should be cancelled, in my own concern is that then Lawrence also find that much weight will be learning single judge. And an observation was also made by a lot that very was also in relation to the member, Babulal Kaha. Now, Lawrence find that in the charge sheet which has been submitted by the SOD, the allegations in relation and what has weighed in the learning single judge is that as far as that charge sheet is concerned, the charge sheet only said that Babulal Katara had disclosed the paper to Ramuram Raika for his son and daughter. But the learning single judge says that Babulal Katara is involved in mass leakage and allegations have also been made in relation to the 2022 teacher second grade examination. But the entire charge sheet which has been submitted by the SOG as against Babulal Katara, which has been considered by the learning single judge as being a total inaction of the or rather irregularities at mass scale being conducted by the RPSC. That has made with the learning single judge. the SOG says that he was responsible in relation to the paper being diverged to Ramuram, right? And that is the only allegation in that SOG FIR. But in taking that word against him, what they have said is that in 2022 examination of teacher grade 2, he diverged that paper for monetary benefits. Well, that he did in the 2022 examination would not be sufficient to make an inference that in this case also he would have done it. When the allegation which has been substantiated in the chart, it is only the fact that he was given over to Ramuram Raisa for his son in law. Now, but as far as that aspect also has been totally examined, and in the examination, apart from the entire allegations of all those 7 FIRs as well as the FIRs, arrests have been made up till now. Total arrests have been made.
Yes.
Now, nothing more your lordship is to see is to be done, but never the investigation is gone. Right? In the cases before the right? We are candidly submitting before the honorable court.
Babulal Katara
Yes, sir.
has had the possession of all the papers with him.
That is the allegation. Yes.
And he has disclosed the paper not once, but in all the 3 papers. That means all the 6 papers. That is the allegation.
Only to Ramu.
Ramuram Raika's daughter was only, they were appearing only one, son and daughter, they were open. They appeared only one day.
Maybe.
They appeared only one day. He has distributed it to the other, those gangsters also.
Yes, sir.
They
He has given to.
Please, we want to know, let him first finish, we will ask
Your
you.
lordship may see the chart.
And we'll ask you, you answer.
Your lordship may see the chart that has been filed. It is categorical because those persons have been identified. Those persons have been identified and arrested.
Now, he was thereafter also made a member of the board for for interview.
There is no allegation as far as the interview.
We want to, when things are there before us, we will have to examine everything.
That the RPSC would have to answer.
He was there.
He was there. He was there in the interview. He was there in the interview. But the allegation was up till that stage. That highly appreciated.
What do you mean by systemic failure there?
System.
When the entire judgments which are there before us,
Sir,
they say you interfere when there is a systemic failure.
lordship.
Please address on that aspect. Whether this amounts to systemic failure or not.
Yes.
If the very examining body and the members of the examining body themselves indulge into releasing the paper, who are to maintain the confidentiality of the examination.
So therefore, as far as
You tell us that, address on that aspect.
Surely. Now, sir, as far as the total lordship examine this in respect of the total number of candidates who took the examination, the total number of candidates who passed the examination, and then those who passed the examination, out of them, the people who were called for physical examination test were in the ratio of 1:20, only 3,000 people were only called. You also find the total number of candidates was 7,97,030 applicants were there, out of which 3,86,728 candidates appeared in the written examination. So that when 3,83 candidates appeared in the written examination, because of maybe having leaked to substitute people, I'm taking it to a lot that he has leaked it because the charge sheet says so. So there is no denial about it that he has not done it. He has done it. Now the option is to see that 3,83,000 persons that appeared in that examination, then was it so pervasive that it has been shown by the statistics also that it has not affected the result as such? Maybe some persons have been benefiting. Let us assume that maybe a few score people have been benefiting, maybe 20, 40 on account of that person maybe. And 40 persons have been arrested on account of segregation. So 40% if we include 40% include those persons also who benefited on account of, because that investigation part is complete as far as Babulal Khatara is concerned. The charge sheet has already been filed, so it has already come with the evidence as to how many.
The charge sheet is there with us. The charge sheet is there on record.
Yes, it's on record. It's on record. So, in the 2021 examination, there is no allegation that he was involved with the gang. In the 2022 teacher grade 2 examination, the allegation is there that he was involved with the gang and he divulged it to those gang. So that examination is a totally different examination of.
So in the 23, he is not involved with the gang. That allegation is not there.
Yes, no allegation as far as the charge sheet is concerned in respect of Babulal Khatara that he had disclosed it, the paper to the gang.
Yes, sir.
It is only that he had disclosed it to his one person. And all have been identified. All have been identified. So now I kindly appreciate my lord, out of these 3,83,000, 20,359 have qualified.
There is somewhere where it is written about having purchased for 5 lakhs these
So
papers.
that thing is that the paper of general knowledge was sold for about 15 lakhs and the paper of Hindi was sold for 2 lakhs. To the gangs. But how those gangs were operating has also been now identified that they had access to the papers electricity by different methods. One was that a person went into the center early, half an hour early or 1 hour early, and he was hiding in the office.
Yes.
Took the paper, resealed it, took a photo, and then it was sent to the settlers. And those, they had their own persons to answer that. And those answers were communicated by Bluetooth. Only 2 persons have been arrested.
Yes.
In that respect. Others, the paper may have gone to them, may have copied it, something like that are there. But as a total number of such persons have been identified as only 40.
All right. Anything else?
So that considering the large number of candidates who have passed the examination, there are some allegations with regard to the lordship's benefit being given by Babulal, but you will always find that in that respect, my lord, they were on the written examination, they passed. And thereafter that they could not pass the physical efficiency test or the interview, and they could not be selected. %, they allotted to be out of that, were not even found eligible in the efficiency, physical efficiency test. Out of those 23. Even the allotted to Rahul Khatara, who was a nephew of Babulal Khatara, he has also not been selected in the physical efficiency test. Well, it's only up till that stage where he could have made an influence, maybe in paper leak, etc., maybe it will go in an interview if that person had qualified up to that stage. A few persons may have been benefited on account of that. But the rest of the lottery are all those persons who have been selected on their own merit. And then as I submitted before lottery, this examination which was conducted, surprise test which was conducted was conducted by the Home Department itself of all the selected candidates, SOG, by the SOG itself of all the selected candidates. If we see that the authenticity, then in this, that they themselves try to segregate the people, and on that basis, other certain rate of certain persons who do not qualify. It is there on record a lot.
So that's all, Mr. Sharma. And then we call Mr. Bhalia.
The rest of the judgment in which the examiners have not committed the past in the 2014 that except for the other judgments are already part of the lottery combined. And only for which you would make the lottery.
Joginder Pal Singh. All right. ये रख लीजिए भाई. Yes.
Document most the paragraphs were from the judgment of the judge, which I will go to your office. So, paragraph 145, 149. Sorry, page number 145, 149, 150. It says that it's a time-consuming process. Yes, emphasize 3 times that it's a time-consuming. Tainted and untainted, it will be a time-consuming process.
No.
And others are pending.
In which this judgment?
105 single judgment.
All right.
Single judgment.
Impure judgment.
Yes, sir. Time and again he said that others are still pending.
Page 1, right.
He said that it will be a time-consuming process.
195.
This is another at page 140.
145.
He said page 100 and just above 105.5. Para 105.5. It is noted that only after the arrest of the corresponding issues which require a significant amount of time with new revelation regarding the full extent of the paper leak and its identity to the workload to directly on. Coming to life, certainty, it is expected the number of individuals who benefit from doing one fallback are will be substantial. The fact that the highly disproportionate number of selection departments and he said that because on the 15th examination, the number of persons selected is more. So therefore, that also casts its head on down. That is because of the normalization which has taken place. The theory of normalization is well accepted principle. They adopted the theory of normalization because the exams were on for 3 days. That he has said, and then he has said that it will be a time-consuming process, and there is no infrastructure available for segregating the tainted and untainted. So that is what the kind of thing that has relied upon. My humble submission, but if it's And considering the lot, more considering the fact that how other people, your logic also take sympathetic view of the fact that people who had subsequently been selected for RPSC lot, that process was still on. They had succeeded in the preliminary, then 421%. They left that because they were selected here. There are persons who have left central government jobs, army jobs, to take up this job because they found this to be a better job. They were already there. Now look, those they have resigned from those places. 4 years they have already gone past. They would not have any gain on those services now. Now it would be, and even if your office issue a direction that those authorities may consider taking them back, it would be for those authorities whether they take them back or they don't take them back. They would give another call of action for them if supposing any organization would say that no, we will not take you now. Having done 2-3 years of service there, if they took up this job, they have undergone training, etc. Everything has been done. Now to cancel their examination, and there are a large number of persons with autism. The table which was ordered about the agreement, I have not repeated. Large number of persons who have come from other services.
Yes.
So that is why I'm not considering the fact that here it's a 3-stage selection process. Any person who has benefited in the because of the written examination paper leak would not have succeeded in the physical efficiency and then the interview. Only those persons have been selected who have passed all the 3 stages on merit.
Yes.
Therefore, my commission it is not one of those cases where cancellation could be in.
Thank you. Yes. How much do we cost money? Yes, have this one.
Broadly pretty much everything has to start out. Let me just add on details. And in fact, let me attempt to answer the thoughts, the 90% in thoughts mind of systemic failure. If the person at the end of the affairs which are found to be, if he alleged to have been part of the paper leak format. Well, let me before going on to answer and my submission to single parts case, that was the background. Just what is the situation? What is the human error? So it's a thin line, and the consequence will not determine the cause. Even if there is a large number of people involved, it will not automatically become systemic failure. The result will not determine. So when a systemic failure is where there is a benign flaw, but there is a process flaw, there is a structural flaw in the system that is designed to execute what is required now. Recently, if there is an undesired result because of human error, maybe because of an error or corruption, but because of a human flaw, that's not a systemic or a design flaw. To give it as an example, papers are kept in a room. If there is no security appointed at all, so anybody can walk in and take away that paper. That's a systemic flaw. It's a design flaw. But however, there is a security appointed, but security is compromised through corruption, and he allows one person to get in and take the paper or more persons. That's human error. Therefore, it's corruption as a act would always be a consequence of human error. It cannot be a consequence of a system design. The system has not been designed to promote us. Having said that, the question also would come in that a lot of times the human error may lead to systemic failure. That's also a possibility. That the human error is of such a consequence or of such a magnitude or it compromises the system itself. That's a possibility. So for that matter, every time the analysis of the question has been fact and have been happened. And that matter has already been submitted, that there has been no exhaustive data analytics done in this case. And a lot of examples are given in that which are proven. Let me straight away go to particular parts case because that can answer a lot of questions by the Supreme Court instead of me trying to explain. That judgment matters I believe was just given in minutes by freedom. Yeah. And I will also point out that
मुझे जजमेंट्स का कंपेंडियम था तो
your result comparison, but still just passed on just now.
ये पूरा जो हुआ है अभी दिया था जजमेंट का कंपेंडियम इसके साथ ही कॉल ये
So yes, madam, just that's also case with the head was found to be the compromised person. And in fact, originally they were cancelled, the market traveled to Supreme Court, it was filed back, it was again cancelled, and then it was without the Supreme Court. I not turn to it's the FCC copy whether that probably would be easier for me to that's all the paragraph numbers.
Yes, this is FCC.
Yes, ma'am. 58 minus return. And before I read in minus, in the past year, the record in Vaisakhi's case and sought to be distinguished because here segregation was possible, and in Vaisakhi's case, because the records were destroyed, segregation was not possible. Otherwise, there's a principle that also recognizes on this that segregation. I will tell you that. Para 15 minutes. So that I will not go through the entire, let me just go through one answers in substance. Where does it come para 15?
Please.
In the light of this report, the original requisition for reheard as a result of remand of these cases in the High Court was rejected in introducing gallows case. That was referred to the pariksha bench of the High Court, and High Court had accepted the report, thereby giving approval to that part of the report, as well which has treated the entire selection process to be vitiated. As a result, all the requisitions are dismissed again by judgment of the full-time vendor on so and so. Then into para 20 minutes. It was argued that Mr. Manoj should donate from the chairman of the appellants that those who are facing trial they will acquitted after investigation. Rather than just pause it, that will also question my audit post. That a whole lot of those persons may come forward saying that today they are acquitted after 5 years and they would also drop. That is answered, yes. Likewise, some of those who are even convicted, their appeals are pending and there is a possibility that their appeals are allowed, thereby setting aside the conviction. Therefore, such a decision to terminate their services could not have been taken at this stage. This argument is totally unimpressive and does not hold any water. Such candidates were selected with unfair and illegal means cannot have the capacity to say that they should be vindicated in service and allowed to continue till their appeals are decided. In any case, having found that they are plaintiff candidates and their entry public service was spoiled, the decision to terminate the service becomes perfectly justified. In respect of these appellants, the ones who are before the High Court has found that FIR has been registered against them, and they definitely carry a trace, stain or blemish that they were tainted. FIRs were registered by during investigations the Vigilance Bureau recording statements from Mr. So and so under section so and so the modus operandi of conducting the management for the examination of the store career. Question papers were given to Mr. So and so to be shown to the candidates who would appear in the examination conducted by the case. The same was to be collected from the official residence of Mr. So and so. The above procedure was also followed at the residence of the mother of Mr. Satyu, Mr. Jarman Singh was deputed to the residence influential person pursuing the person which was the In this background, the High Court rightly covered these persons as tainted persons, ascribing following meaning to the expression taken. The word taint as per the new sort of also visually can be expressed in meaning of a stain or a blemish. It denotes some inequality a contaminating or corrupting influence. It can lead to mean an influence with anything objectionable or to contaminate or infect. The word taint when used as a verb means dishonor, destroy, integrity, initiate, transition, regenerate, morally. So those who are also in the process of being prosecuted but also not allowed. And whether then the next step shows that the non-candidate candidates, they were recruited, there's a list of non-candidate candidates. Then my lord will permit me to come to para 28. Further discussion ensued on the approach and parameter para 8 appears that list of 40 persons who, as per the investigation carried out by the Vigilance Department and the compilation made by the committee, ensured their selection by way of manipulation. Out of those who have approached the court, their cases have already been dealt with in the first category, resulting in the dismissal of the appeals. The committee thus found that orders, mainly the appellant's hearing, were not tainted. It thereafter proceeded further to deal with another aspect, namely whether the entire selection process could be said to be efficient. The committee has recorded its reasons for the aforesaid answer, conclusion, and concluded at the end that the processes of selections were clearly ripe and abounding with manipulation, carried out by a well-planned scheme of deception, forgery, and fraud, executed for showing favor or for consideration. As such, the committee opined that the entire process of selection deserved to be set aside in their entirety. Include that, but after taking note of the seminal fact relating to the ways on which the Supreme judgment discusses the importance of PSC, their role and its duty, responsibilities, as well as expectation of a common man who is, as per the preamble to the Constitution of India, entitled to equality of status and opportunities. Thereafter, it posed 3 questions which needed consideration by the court. Whether 23 selected candidates were facing criminal trial can be described to be tainted. 2. Whether the selection of other candidates who are not facing criminal trial can be described to be vitiated in view of the detailed investigation carried out by the Punjab Business Bureau. And 3. Whether the state government was fair in giving chance of second examination, which is not been done. Para 30. After taking note of and discussing various judgments, the court upheld the action of the commission cancelling the selection process when found to be vitiated on account of not following the procedure of selection, smacks of malafide and malpractices. The full text held that here also the entire process suffered from manipulation and what we treated as vitiated. From the report of the committee, it shows the constituting a decision of the court in Canada, which has been accepted by the High Court. It is apparent that the committee has not found a against these 21 persons, in respect of whom we are deliberating on the issue involved. At the same time, on going through the process, the committee of the belief that the selection process was vitiated, and therefore the result was to be cancelling its entirety, including that of those non-technical as well. The question that calls for consideration is as to whether the entire process could be rated as vitiated because of purported manipulation, fraud, and fraud. Or to put it otherwise, once the non-tainted persons are segregated from tainted ones, would it still be justified to squash the entire selection, even when non-tainted persons made into the service because of their manipulation? It was argued by Mr. So-and-so, appearing for the appellants, that the mandate of CALO was limited to one aspect only, namely to segregate the cases of tainted candidates from non-tainted ones, and it was possible. It was their submission that after this task was successfully accomplished by the committee, there was no opinion to go into the second aspect, which was not part of any direction of the report in CALO. It was further argued that the findings on 2 aspects are self-contradictory. Once it was accepted that some of the candidates were innocent, who were entered the service by virtue of their merit and not because of any external consideration, and these candidates would be segregated as well. Such a finding to the effect on the second aspect, that the entire selection process was vitiated, would not be right. We find force in the forces argument advanced by the learned senior counsel, appearing for the applicants in these the 2 conclusions of the High Court appear to be anti-technical. Once it is found that segregating tainted from non-tainted candidates is possible, and is achieved also, other conclusion is incompatible with the first one. And I will just conclude this one para 37, where the court is referring to another judgment. We would like to reproduce here under some portions of judgment of Ibrahim Callow, and while reproducing it, my lord can see point number 50. In those cases also tainted cases were separated from the non-tainted cases only. Thus, in the event it is found to be impossible but highly improbable, could advance orders of termination have been issued. In case of this nature, thus the question which requires serious consideration is as to whether due to mistreat of some candidates, honest and meritorious candidate should also suffer. To paragraph 59. It becomes crystal clear that concern of the court was that besides the some candidates, honest and meritorious candidates should not suffer. Therefore, endeavor should be made to segregate the into candidates from those who were without any stigma and had been selected because of their sheer merit and not on account of any illegal qualification. We would also like to review some of the parts of the conferring journal authored by the Rajasthan Bandari as Oxford and laws, with the opposite passage eloquently indicating. Undoubtedly, in the selection process, there have been manipulations and irregularities at the behest of RPSC, the then chairman, Punjab Public Service Commission, on the careful scrutiny of the fact and circumstances that create, in my considered opinion, the High Court ought to have made a serious endeavor to segregate the plaintiff from the non-plaintiff candidates. Note the task was certainly difficult, but by no stretch of imagination was it an impossible task. The High Court has not considered the case from the proper perspective. The consequence of en masse cancellation would carry a big stigma, particularly on cancellation of the selection which took place because of previous charges of corruption. The question arises whether for the misdeeds of some candidates, honest and good candidates should also suffer on an en masse cancellation leading to termination of the services. Should those honest candidates be compelled to suffer without making any fault on their part just because the respondents find it difficult to segregate the cases of plaintiff candidates from the other candidates? The task will be difficult for the respondents, but in my considered view, in the interest of all concerned and particularly in the interest of honest candidates, the states must undertake the task. The unscrupulous candidates should not be allowed to damage the entire system in such a manner that innocent people also suffer great ignominy and stigma. You know, the concluding portion at 40. In view of the above, the issue of entire selection process having been vitiated would have arisen only if the findings of the committee were that it was not possible to distinguish the cases of plaintiff from the non-plaintiff. And there was a possibility that all of them would have got the benefit of wrongdoing of which was reviewed in the conflict. Fortunately for these appellants, it is not so as they have been found innocent, the appellants get ensconced, earning a safe place once they are removed from the category of various persons. Those are plaintiff candidates are right to receive their consequences, but the innocent person cannot be punished with them. Thus, it is difficult to accept the following conclusions of these. But I will also just point out that therefore, what has already seen multitask here, this one. But there is a twofold test which has to be answered in the affirmative before the entire cancellation can take place. The first question is whether it's a systemic failure or a human error. If it is a systemic failure, it's only then the entire process can be cancelled. But then there is the second aspect and the second test, which is if there's a systemic failure, whether candidates can be segregated into plaintiff and non-plaintiff. If that question is also minus in the affirmative, in the sense that it cannot be segregated, only then en masse cancellation will take place. If either of the two questions is answered,
Yes.
in the negative, in the sense that if it is a reason of a human error, then if a human error is traced to whoever has benefited, only those will do. And the second question, even assuming for a minute that there is a systemic failure, if no possibility of segregation is there, only then it can be cancelled. And my notes would recall and also put in a pertinent question that what will be the test of truth? Whether it is an absolute truth, or it's an absolute negative truth, or it's somewhere in between where probability will have to be examined. So there will be different levels of probabilistic, preponderance of probability, and very certain probability. So minus that's the domain in which it will move in. If there was a certainty of either side, there is no question of any dispute. Then whether either which way it is, it will go there. Assuming for a minute that we are in the state of gray, where it is based on probabilistic assessment, then what is the test? Therefore, minus the test is not whether there has been the test is not on the innocent to prove. It is for the state or the authority who's taking a decision to establish that A, there has been a systemic failure, and B, it is impossible to segregate. And that is why I take on and emphasize this also. It would be difficult, but it is not impossible. And that's why in Vaisakhi's case, the court went on to the view that since there, the record itself is not there, therefore there is no possibility. And then in para 15, Joginder Pal's case is referred to, and the court said that this is the principle. That if it is segregated, it has to be, and para 15 of Vaisakhi's case is very specifically referred to the same. So what is in my submission? Here in this case, there has been enough factual scenarios pointed out where even I go down to the extent of saying that even if it doesn't establish beyond doubt, it definitely raises the question of who has been involved and who has not been involved. And there are candidates against whom there is nothing so far. Coupled with the fact that the SIT states that segregation, who is the person who will make that statement that segregation is there or not? Is the person with the investigation. If the person or the body which is examining and investigating says that it is possible, then there is no occasion to find fault with them. This minus in this particular case will go a step further. That second report is gotten considered. It's not a question that the court overrides that opinion or not. That opinion has not been there before the court. And minus, I need not say the cardinal principle of relying on a piece of evidence or anything which has to be taken cognizance of. It has to be seen in entirety and not in pieces. So if there is something which is to be seen as a piece of evidence, it has to be seen in its entirety. If a report has to be read, it has to be read in entirety. And if part of it has to be discarded, there has to be reason why it is discarded. It is not to be picked and chosen that one part of a report or an investigation or an evidence is to be looked into and the other to be ignored. That can never be the endeavor of any principle of fact finding or even trying to arrive at an assumption. So in this particular case, status, it was already been let out to my lord that the second report has not been considered at all. And now it's in Vanshika's case also, we need not refer to it again. The question of this segregation is very specifically important. So therefore, this just to summarize, even assuming for a minute that the fountainhead or the person who had those papers and tweaked it. Now, if the consequence of that, wherever that paper has had removed in a complete vagueness, there would have been a question of whether it's an unknown territory or not. But here in this case, the investigation finds all the questions, makes complete the chain. If the chain is completed, then the identification is complete. Then even if it is the person who has held that paper in his hand, and by the chairman, even somebody who was only the courier of that paper, if he has that paper and he leaks it, it's the same situation. It doesn't make a difference whether or not with authority. The question is that the paper has been leaked. Now, once the paper has been leaked, and it is leaked because of a human error, that is one. At this stage, I'm on the next question. Assuming it is a systemic failure because nobody could catch it in. Then also, whether that exercise of completing the chain has to be done, which has been done in this. And once those identified persons are there, there is no question to be dwelled upon whether it's a vague situation and an uncertain number of people have got hold of it. So in this particular situation, with that principle in place, there was no question of dismissing the entire or cancelling the entire selection. But one more question will have to be considered in this, why the cancellation of the entire process is to be between. Because now, minus the Supreme Court also agreed, and I have a recent judgment also saying that when this is all in the domain of why this should be cancelled or not cancelled is essentially a function of fairness. Even a lot of people have taken advantage of an unfair means. It is unfair to the people who have used the right. And if it is cancelled en masse, it is also unfair to people who have been selected using the right. So the question of fairness will never be answered in the absolute. always, my lords, the principle of proportionality will also have to be looked into. That what is the proposed action's consequence lead to? So even in issues where there is a question of fairness, or it's a function of fairness which the court is examining, it will have to be looked into that the action that is proposed to be taken, or the decision that is taken in, will be proportional in the facts and circumstances of the case. And why I bring this up, my lord, here is, and those statistics are already been given to my lords. Two sufficient. Lot of persons, and the data is here with us, have left central services and joined India. They have left state services and joined India. They were selected parallelly in multiple examinations and then
Influencer. That doesn't influence us.
Why? And
In West Bengal case, the same situation was there.
I'm coming.
There's an observation there.
Yes, my lord. That is why I'm coming to that. I'm alive to that observation. But by this coupled with another fact.
It's only that we will be looking at them. They are tainted or untainted.
That is there.
Can we separate?
There is one more. There's an interesting fact which is coupled with this, and that is why I'm bringing this.
Even those who have been in service,
My lord.
they have been found to be in the tainted category.
That is true, my lord. So I'm coming to that. Why I'm submitting this and why this question of proportionality is coming. Whether there is a notification which provides that in these police services, while a person is on a probation, he is not allowed to write any other exam. So there is also a question of opportunity loss. There is, my lords, when somebody is selected and he is working as a professional, he is not even allowed to write other exams. So therefore, my lords, the theory of proportionality coupled with legitimate expectation on this, when you specifically provide for somebody to not participate in any other, because why I am submitting is this, that at this stage, if a job is taken away, it also amounts to a civil death of a person. And therefore, the level of reasoning that is required to throw him out of the job has to be of a much higher disposition. Because three things have happened. A, he might have left his job. My lord is perfectly right that because merely because he's left a job, he will not be safe. I am not of that at all, my lord. But when I am submitting in
If he is holding a paper with him,
that's right, my lord.
he would be more happy to leave that job and come here and come get a good meritorious post.
I'm submitting on it. That is why, my lord, that question is if he's tainted or not. If he's tainted, a tainted person is not protected, whatever be type.
Yes.
What I am submitting is those who are not tainted, only because of difficulty in segregating the tainted and untainted. If you are going to dismiss all of those, I'm from that perspective, I'm not even for a minute suggesting that somebody who's been found with that paper is to be protected because he got something or he is not being allowed to participate elsewhere. Not at all. What I am submitting is the persons who are untainted are being made to leave their jobs because the state or whoever the authority is finds it difficult to segregate. The consequential, the proportionality of the consequence of the decision is disproportionately higher for them. That's what I'm submitting. Therefore, it's balancing act. At the end of the day, it's a oh my God. We decided with a difficult question on deciding the weighing scales on the fairness test. Fair enough, and it's a difficult task. But my endeavor is to say that those scales are heavily weighing in my favor. Those who have been selected, who have been untainted, and coupled with the fact, and this is only an additional point of that why this proportionality has to be seen, and for me the consequence is very high. It's not just that I'm untainted, coupled with the fact that while I was here on probation, I could not have written any other exam, and so some of us have left those services and come in. And when that is why if I was to see the learned single pensions order, those who have left their services and come in, and those who are untainted will be allowed to join that. That's a direction I was given. Now there are two things here. What happens? That direction will not apply. The Honorable High Court made short permission to give that direction for central services. Those people who have left those and come in there. And B, it also doesn't save them their seniority. That's a different question to be answered in a different matter, but the fact remains that even the learned single judge was conscious of the fact that there would be certain people who are not talented and who have left their jobs undone. So if they are to be protected, then why not that protection can't be only for some.
Question would arise whether those people went back to those departments and tried to join. And if they were refused. We can't be presuming such a thing.
So if they want to-
You are appearing for those persons who are untainted, no?
Yes, sir.
Now,
They don't have to hear on that.
did they go back
Is it-
after
Yes,
the,
it's a- yeah, I'm very clear. Yes.
that is, you are choosing to continue.
Yes, that's what I'm submitting. If
Yes.
I don't have a real
Taking
interest-
service is another thing. So far as court is concerned, court passed an order.
My loss.
Did you try to go back saying that this examination is over, our fate is sealed here?
Central services, that direction is not there in any case, can't be one.
Why can't it?
And they have-
Union of India is not governed by the orders of the court.
The directions in my submission and also they don't have a lien on those.
That's another thing. That is
So therefore, my.
that is an argument will come from there.
This, I can't be left to the fate that this will happen when it comes in. So what I'm submitting is, I'm not even questioning the judgment of that. I'm saying whether the learned single judge is also conscious of the
You are
fact.
not possibly challenging that part of the observation of the court.
I'm not challenging, but I just make myself clear why I'm submitting on this. I am not challenging that part. What I'm submitting is that even the learned single judge is conscious of the fact that certain persons who are untainted have been dealt a difficult blow, and therefore the direction comes in. Otherwise, it's the direction. If everything is to be cancelled because nothing can be segregated, why protect certain persons? If one category of persons has been protected, then my lords, it is arbitrary on why the other category of persons are not protected. Therefore, my lords, I'm only to that aspect. When it comes to the consequence of cancelling, that's why I'm only here because my lords only appearing for the selected candidates. There is no candidates. So my lords, I am in any case not trying to submit on what had happened. It was a leave, not leave, who was involved, who was not involved, is not in my domain to make any comment on it. I am only concerned with the consequence that has been dealt to us after it has been found, rightly or wrongly, that there has been a leakage of. Now, yes, once that has been found, whether the consequential action ought to have been taken of cancelling en masse, without considering the theory of proportionality, without considering whether segregation and non-segregation is possible, and without considering the fate of these persons. Now, without considering all of this, if the cancellation has taken place, my submission is that cancellation, the en masse examinations. And for those minors, the proportionality which minors is I am submitting on opportunity loss, as well as this direction that is given. Of course, minors, I can't have a quarrel with the direction which says that certain persons are allowed to join. If somebody else gets a benefit, I can't be questioning that. If I am not getting a benefit, I can certainly question that. But the purpose of my submission is that the learned citizen is also conscious of the fact that not all persons are involved in these practices. And therefore, the protection is given. So, my submission is that this, and I am just giving minus 3 examples of what has happened minus. In the minus, in the report minus, there was a specific allegation at some place to show that this could have gone en masse to people. That there is a group that was created with an exam master group in the electronic media. So if it is on the electronic media, the presumption would be that it's very easily distributed. Because we've already filed, there is an application which is filed in one of the petitions, which shows this screenshot that no such group even existed. That existence of group itself is not questionable, it is not there. And only basis on surmise is that somebody alleges that is there and the honorable court has relied on the same group. That group does not exist. So that fact finding minus on the face of it incorrect, that application on 4127 is available. That such group does not exist. And this paper minus there is nobody's allegation that it has been published on the electronic media where it has been mass circulated. In terms of physical distribution, that identification has already happened. Therefore, my lord, just as an example, I wanted to point out. The other also, my lord, I wanted to point out, there were two examples given in. One which has been filed with the application, which is something to be filed by the respondents. And this, my lord, I am raising not to question the investigation or conclusion, but only to show that there are various doubts that still remain. If doubts remain, no assumption can be drawn against us en masse. And the second was as a classic example, my lord, that was an allegation against that Mr. Katara, that even in interview he was sitting in, and he had specifically mentioned that to come in certain clothes and I will take care. It's very interesting. There were two sisters. That very person for whom this allegation is, a real sister is rejected in the interviews. And the report says it's rejected in physical and incorrect. So whether these allegations, and I do not mean to say that these examples of factual questions should be considered because these is for an overall evaluation for the investigation. But like we should not be submitting on individual examples. The petitioner also should not be happy on specific examples only. Unless it is very, very convenient for a public interest litigant to say that this came in with an allegation that he was sitting in an interview and this person was asked to come in particular clothes. But the other sister also comes in and she doesn't react like that. So that only raises questions. Who can answer them? That can only be answered by the investigation. If somebody has a quarrel with that investigation, that needs to be challenged. We have its appropriate evidence. But anybody else, for the purposes of cancelling the examination, whether it is the petitioner or anyone, cannot take instances and arrive at their own conclusion, which is contrary to or a deviation before the investigation parts. Unless the investigation is put to challenge and held to meet, whatever the fate, that is pending trial. So in fact, commenting or taking something out of leave of that investigation would be essentially by submission disturbing the trials. That cannot be permitted. The only situation where this order of cancellation could have been given is if the investigation had brought out a specific conclusion of systemic failure coupled with the conclusion of no segregation possible. And then it would have been in the domain of the court to examine that in this situation, whether en masse cancellation is possible. Here in this case, both things are in fact in the negative.
All right.
That judgment by the time we pass on wherein whether that proportional state for state of exam versus I'm grateful to my colleague if I may just pass on para 40 and 49 and 50, which was on this state of exam versus Malad Aravinda Rabha, wherein Malad should be the exclusive domain of the state to decide whether it should be cancelled or not cancelled. In this case, Malad states stand absolute clear that if segregation is possible, then they do not want to cancel.
State of Assam also.
Right?
The judgment?
Yes. I will just have a pass on that state of versus Aravinda Rabha. I will just have a pass.
Your citation? Citation?
I have the copy from the Supreme Court, madam, so I will give you the printout. It's seriously number 250/2025. State of Assam versus Aravinda Rabha.
Raghav.
Aravinda Rabha. RAVH.
When has been decided?
Well, I have a copy from the Supreme Court.
I given the date of the
Date, sorry. This is 7th March 2025.
It says that it is the state which has the exclusive domain.
State domain and minus proportionality will have to be seen in even where the court's domain would be to look into if there was any mala fides inward, etc. That's obviously whether that is now said. So, with any further query and.
Anyone else to address? Do you have to say something?
On behalf of the other applicants,
On behalf of?
the applicants who are members against whom.
Say address, whatever you have to say.
I'm arguing from the read of Sunday Smart Company. Item number 10.
Yes. Start.
But in the agreement paragraph 30, here majorly agreed by fourth paragraph specifically from the Validity single judge's order, paragraph number 120, 122, 132 and 140. I reproduce in the memo of Abhi, in paragraph 30, all these paras where we are including that certain static remarks have been made against us without ever having allowed us an opportunity to defend ourselves, or whether there been any opportunity given to us to testify against that report or in favor of them, which the learned single judge have made the basis of the issued order. Words. If I may read the paragraphs which are making certain remarks against the appellant, with your lordship's code, paragraph 120. In furtherance of the aforementioned circumstances, the involvement of additional members of the RPSC has come to light. In order to ensure that Shobha Raita secured good marks in the interview stage of the recruitment process, Mr. Ramuram Raita met with the then chairman of RPSC Ramesh and other RPSC members, including Mr. Babudar Bedara, Mr. Nidhi Sharma, Mr. Sangeeta Arya, and Mr. Jaspreet Arya. During these meetings, Mr. Raita requested the members to ensure that they got to pass the interview.
This is what he is quoting. He is just quoting something which is part of the investigation report. It is not his comment.
Plus, this turns into a finding against me saying I am the kingpin.
Where is that right?
The audience could find that at file number. Para number. Regards to.
Mr. Saman, not like this.
I'm so sorry, but
You have to be prepared what you want to show.
I'm so sorry. Because I had a 140. I was just trying to explain my memo. Looking at page number 33. I reproduced that. Para number 140. The involvement of the former chairman of the RPSC, Mr. Sanjay Chaudhary, adds to the gravity of the situation. Mr. Chaudhary not only instructed Ramuram Raita regarding the future course of action concerning his sons and daughters' interviews, but also actively participated in the interview panel himself. He is the head of the institution of such esteem for his importance is inherently disobedient towards his own duties. It portrays an image of discipline public employment. The mechanism employed to leak papers and prejudice the interview process resembles the spider web of compromise integrity working together to compromise the process. The biggest and most unfortunate loser in this scenario is the hardworking, candidate who is with full knowledge of the mechanisms that the backbone of the institution are hard to pass the recruitment with hope for ensuring a better life, not only for themselves but also for their families and the community at large. It is not difficult to imagine that a society in which public posts are held by individuals with current backgrounds cannot preach confidence in public institutions. At para 141, at the center of this distrust lies the RPSC. The situation is both alarming and unfortunate. Infuriating to say the least. Against this backdrop, the measures adopted by the RPSC, such as cancellation of exams, enhanced candidate verification, and increased readiness for exams, as outlined in the framework alone, are exposed as mere counsel. These measures shall not prevent any breach of examination integrity because the integrity will not be breached solely because by antisocial elements of society, but also by the very members of the RPSC who are interested to ensure that such antisocial elements cannot make a mockery of the system. The original trust in the RPSC is to be malpractices has far-reaching implications for the credibility of the recruitments. And more specifically, with respect to the chairman, there is another statement which is recorded at paragraph number 120. There have been hearings. Because I'll come to that. So, now what is happening about this? On the issue where there is no allegation in the report, no allegation in the charge sheet against the chairperson being involved in this matter. The learned single judge has gone on to accuse the entire matter wherein my involvement is being shown. If the lordships could see, the entire case was that this person whose son and daughter was participating in the interview, someone may have come to the house of some person, investigation is done, the investigation agency does not hold the accused for it. Then also the learned single judge has gone on to say that they have sat in the interview, therefore they are deemed to be involved. Now what the procedure is, I have reproduced Rule 21 blocks of the rules. If I will apply a copy of the rules, how the interview panel itself is formed. I have also listen. Now, that's in Rule 21, authority for conducting the competitive examination is there. Now, I request a kind indulgence at page 30. It starts from page 29, bottom paragraph 6. Candidates who are declared successful in the written test under subrule 3 in the physical efficiency test under subrule 5 shall be eligible for aptitude test and interview, provided that the number of candidates called for aptitude test and interview shall be restricted to 3 times the number of vacancies on the basis of merit based on the aggregate marks obtained both in the written and the physical efficiency test, except in the case of scheduled class and scheduled class candidates which are be eligible for interview in case of excess of the prescribed limit if they qualify for the written examination of the physical efficiency test. Now, I wish to rely upon Subrule 70, the aptitude test and interview of the candidates qualifying physical efficiency test shall carry 50 marks. For the post of sub-inspectors in section 1, 2, 3, and 5, and platoon commanders in section 4 and 6 shall be held by a recruitment board, which shall consist of the following members. Now, one is chairman or member of the commission to be nominated by the chairman, an officer of the police department nominated by the commission in consultation with the DG cum IGP, not below the rank of IGP. An officer of the police department nominated by the commission in consultation with the DG cum IGP, not below the rank of deputy IGP, and one psychologist nominated by the commission. The recruitment board shall award marks to each candidate in respect of the suitability to the post, taking into consideration personalities, evidence, fact, behavior, specialized training, aptitude for the post, judgment, leadership, and knowledge of Pakistani culture. The marks so awarded shall be added to the marks obtained in the written test by each such candidate. Candidates holding degree or obtained in written test in diploma in technology or NCC who have offered police administration and cover the papers for the degree examination may be used. Now, my argument with respect to this is what? There is an entire recruitment board. It is not that only one person is giving the marks. Incidentally, the head of the SIT has sat in those recruitment boards not once, not twice, but 14 times. If there was any allegation of a bias or a malafide, they would have raised a concern there. It is not the case.
Incidentally, Lord, the chairperson during whose tenure this question paper was given to Popular Katara to be made, he's not made a party to the appeal, neither any involvement is strong. What they say is that because that question paper was given to Popular Katara to be made, so there is an involvement at the hands of the current chairman, which is absolutely wrong. I was not even on the post on the day when this question paper was made. So what happens, Lordship? The ex-chairman during whose tenure, the question paper is given, the work is given to an individual. He makes that there is no indication that the question paper is given in the hands of the member of the committee. In the interview process, at that point in time, there was no indication against this member. In another recruitment, in a teacher grade 2 examination, the allegations arise, we cooperate with the police authorities, we get this person arrested. When this person was arrested, the investigation, he reveals that I have participated, I have given marks to XYZ person. So that is not under my head. Furthermore, all these police officials, while sitting in that recruitment board, would have raised alarm there and then in case there was some discrepancy in any of the marks. These candidates who are first qualifying the written test, then passing the physical examination, then coming to the interview. So it cannot be said directly that the involvement of the chairman is there. Even if, presuming even if, then there has to be a trial in that case. Directly alleging that X person is the kingpin without having the need to go through a criminal trial would defeat the purposes of principle of
Where do they say that you are a kingpin?
well, I'll just showcase that. Give me 1 minute's time. I will just showcase that. The kingpin word. Just
If there is a finger raised at the entire institution as such,
no.
is the head of that institution not responsible?
I got on the margins. Then in that case, conduct of each individual has to be safe. A person's
Would it be required to make an observation relating to examining the conduct? If the institution itself,
yes,
there is found to be a failure of the institution to conduct the exercise which they are required to do in terms of Article 320. And they have shown, if we take the single judge observation, findings relating to the examination as such, how is he wrong in making observations relating to the chairman? Because the chairman would be responsible for whatever has happened. He makes a comment.
then in that case,
Yeah, and you, being the chairman, would have to take the responsibility.
now in this case, I was not the chair. That's what I am missing. If I would have been, I would have taken all the responsibility. Here also
During this examination, you were not the chairman.
it was the previous chair. It is
You
only
joined
the
when?
stage.
You joined at what stage?
After the physical test was conducted, I was joining the RPSC after at the interview stage.
All right.
Proceeding that happened for that examination was the interviews. At that stage, the involvement of
So the chairman prior to you,
yes,
no comments on him. All right.
no,
That's, no, all right.
as I was relying on good people, for a fact that there is an interview board.
No, no, that's over when you are not, that's all. Oh, anyone else?
I just have to showcase certain things, certain points on the issue of why those animals cannot-
But once you are saying you are not responsible, you are not responsible. End of it.
then can be bad.
Since you were not there, we will examine that aspect.
Then allegation states.
Obviously, that means what you are saying is that you are not responsible for that.
Very well. And my another argument is that either the single judge accepts the SIT or rejects. A pick and choose approach cannot be there. Considering the fact that the SIT holds him to be completely not guilty. No involvement. SIT says these two members.
His comment is on the other aspect. Once the SIT report is there, once those things are there, you being the chairman, it was your call to take that to cancel the examination. Don't you do it in other cases?
Very well.
In RPSC doesn't cancel examinations once papers are leaked.
In teacher grade to anyone, because
Why did you not do it in this case?
this examination is conducted by the police department. That's the thing. Sir.
Selection. The examining body is the PSC. Don't say like that.
Plus, the issue with respect to conducting the examination with the PSC, the discretion lies with the recruitment board which consists of the principal. It is not.
That is the interview part. That is the only the physical education efficiency test. Thereafter, the interviews are conducted by your people. Your member, the PSC member has to be there,
Yes.
and the recommendations are by the PSC.
Very good.
See, the cancellation can be also by you.
Because on that issue, once this.
Why did you not cancel it?
Because the examination already been.
When the first SIT report was there, Mr. Counsel,
Yes, sir.
when the first SIT report was there with you, why did you not cancel it?
Because by that time, RPSC had become functus official. Because
You-
once they
you-
accept the recommendation, the persons are appointed, the state government would then become the authority to take a decision with.
All right. All right.
Well, we can just showcase that.
We have understood what your argument. Let us
Sir, may I kindly-
let us try to conclude the case now
May I
as
kindly-
quickly as possible.
But only on the point of why remarks could not have been made against me.
That is there. Then give that in written.
But the, and then we put the report is only 24 days. I'm obviously on that data, it's all to deal with.
About to, but you are not.
Very good. But argument on that issue that, yeah, this is become from the official once they sent the recommendation, now it is the purview of the state, whether they have to cancel the recruitment or not.
It's not that simple, sir. RPSC remains in control. You, even while appeals, even after the recommendations have been made, you challenge the action of the state government also. You are a counsel, you have been regularly appearing. You know, you have challenged all those cases. It's not that a PSC leaves things like this, but in this case, surprisingly, they left it.
Because in most of the
Yes.
examinations, we have, the moment it came to our knowledge, we cancelled.
Anyone else?
Item number 8, 9 and 11, Mr. Deepak.
That's Mr. John.
और यहाँ चार्ज शीटेड है 96 नॉट पे इन्वेस्टिगेशन पेंडिंग है ना रिटर्न पेंडिंग 13 ऑब्जर्वेशंस हमारे अगेंस्ट में पास केवल लिमिटेड सा हमारा प्लेयर है सा उन एक्सपर्ट्स कर दीजिए और जो ऑब्जर्वेशन है वो आप कहें तो सर
That is their part.
तो करप्शन का हमारे ऊपर एक चार्ज लगा दिया गया क्योंकि करप्शन को लेकर सच में हम ना तो एफआईआर ना चार्जर ना इंक्वायरी ना इन्वेस्टिगेशन नहीं मेरे लिए लिखा गया एक घंटा लगता ढाई जबकि पूरी इन्वेस्टिगेशन में पूरी चार्ज कहीं कुछ सिंगल वर्ड लिमिटिंग नहीं आया इससे मॉडर्न वर्कशिप मैं केवल एग्जीक्यूटिव का पार्ट थी जो कि संजय फिफ्टी हेड चल रहे थे चेयरमैन वो थे
You are in Manju.
मनु शर्मा ना तो मैं उस इंटीग्रेशन का पार्ट थी ना मुझे कोई अपॉर्चुनिटी ऑफ मेरिंग मिली और ना ही मेरे अगेंस्ट कोई प्रेयर थी और ना ही इश्यू एग्जीक्यूट करने के लिए कोई इम्पोर्टेंट था सर तो सबमिशन करना ये मेरे अगेंस्ट आज की तारीख में पूरी फाइल में कुछ भी नहीं तो ऑब्जर्वेशन से वो करप्शन के हैं घर का मिलीटेंट है इससे रिकॉग्निशन से इससे और बाकी हमने रिजाइन बाकी कुछ नहीं है सर पूरी फाइल में कहीं
And that is your decision कि आपने रिजाइन कर दिया या अगर रिजाइन कर दिया तो आपका इसका मतलब आप मानते हो आप रिजाइन करते हो तो इसका मतलब यू है what was this as a reason to resign? That means you accept.
वो एक्सेप्ट नहीं किया हमने डिजाइन में लगाया रेजोल्यूशन करके लगाया फर्स्ट बताया था वो तो केवल इसलिए मैं दो लाइन पे ये ज्यादा लंबा नहीं है फर्स्ट बताया ये देखें सर पेज नंबर 226 पे है समय ने निवेदन है कि मैं श्रीमती इच्छा सदस्य की तौर पर कार्य करता हूं मैंने अपना पूरे कार्यकारी और जीवन अत्यंत पारदर्शिता और ईमानदारी से काम करते हुए किया है क्योंकि जब जब कोई बढ़ती प्रक्रिया में उत्पन्न हुए विवाद के कारण जबकि मेरे विरुद्ध किसी भी पुलिस संस्थान अथवा किसी भी ब्रांच एजेंसी में ना किसी प्रकार की कोई जांच संवेदन, ना ही मुझे किसी भी प्रकार में कभी माना गया है। फिर भी सार्वजनिक जीवन में शुचिता के सदैव पत्थर होने के कारण आयोग की गरिमा, निष्पक्षता, पारदर्शिता को सर्वोपरि।
चौहान साहब आप ये बताइए, आप तो खुद क्रिमिनल की वकालत करते हैं।
Lordship,
Can't the court make an observation relating to some member, even though the police may have left it, and say that yes, this person, that this person at this stage, whether opportunity is required? If suppose 10 people have been made an accused, and while examining a case, the court reaches to conclusion that seven persons more are also involved. At that stage, are they going to call those 7 people and hear him? We want to know from you, in the criminal law, is it there? Not there, na? हाँ ना, तो बोलिए तो सही। अजी साहब आप बोलिए तो सही, ये बात तो बताइए। If somebody is found culpable in a particular, so if the investigation has been conducted by the honorable single judge, and during his investigation he reaches to conclusion that apart from those whom police finds, these people were also involved. That is why you have resigned.
पूरी फाइल में नहीं, कंक्लूजन किस चीज पर आएगा? या तो कोई मटेरियल आएगा, या कोई एविडेंस आएगा,
That's
या
all right.
उनके सामने ऐसा कोई
they-
डॉक्यूमेंट है, कोई नहीं, सेंसर एविडेंस की इस बात की पूरी फाइल।
It is not the remarks, it is the finding relating to the culpability of the members of the PSC.
फाइंडिंग्स नहीं है वो, स्पेशली उन्होंने लिखा है, मैं आपको पहला देखे
लिखा है ना उन्होंने, आप ही तो अभी बोल रहे थे क्या
मैं बताया
घर का।
ये सब देखें आप, पेज नंबर 175 का है, इंटरनल पेज नंबर, और मैं बात बताता हूं। बियॉन्ड आरपीएससी मेंबर्स, आउटकम कलर इन्वॉल्वमेंट इन एग्जामिनेशन पेपर, अदर आरपीएससी मेंबर्स आर आल्सो implicated in compromising the sub-inspector's 2021 recruitment process integrity. Popular Canada advised Ramuram Raikar to meet RPSC chairman to ensure favorable interview panel for each other. Ramuram Raikar met chairman Satish Utri who participated in Ramesh Raikar's interview panel, awarding 28 marks. Ensured Popular Canada involved in Shobha Raikar's panel. Chairman Satish Utri was thus actively involved in the interview stage. Ramuram Raikar also interacted with the members Manju Sharma, Sangeeta Arya, and Krishnan Raikar regarding the children's citizens. These members' participation suggests systematic corruption within the RPSC, compromising the recruitment process in the of both the examination stages. अब इसके बाद देखिए सब next ये आता है पेज नंबर 189 है और पैरा नंबर 124. The Hindi idiom "Karka Lady Karka Die" at least includes the technical circumstances surrounding the sub-inspector recruitment examination 2021, wherein every guardian is invested with the same regarding the sanctity of the process, namely the members of RPSC were instrumental in its violation. कहाँ से है? कहीं नहीं है पूरे उसमें नहीं है। जो उनके सामने रिट लगी, उनके सामने जो प्रेयर की, उस प्रेयर में भी ये नहीं है, कोई डॉक्यूमेंट नहीं है पूरी फाइल में, ना इन्वेस्टिगेशन में, कहीं और कहीं से तो ये बात आई कि मेरा इन्वॉल्वमेंट और मैंने फेवर किया हूं, ये फाइंडिंग आई कहां से? कहीं से तो आई नहीं। ये ना तो उनकी रिपोर्ट में, जो उसमें आरपीसी की रिपोर्ट है उसमें, ना एसओजी की रिपोर्ट में, ना गवर्नमेंट की रिपोर्ट में, ना चार्जशीट में सिंगल वर्ड तो आएगा साहब, ये आया कहां से? कहीं से नहीं आया इस पर।
You said the observations are without any documented, documentary proof. Wow.
ऐसी स्थिति में तो मेरे को अपॉर्चुनिटी ऑफ हियरिंग मिल नहीं थी, सीधी सी बात है।
Opportunity of hearing तो नहीं मिल रही थी।
मुझसे तो पूछा जाता, अगर
Finding तो देख सकते।
के सामने ऐसा था तो मुझसे तो पूछा जाता।
मैं
मेरा सबमिशन करना सिर्फ ऑनरेबल कोर्ट से ऐसा कि ये जो फाइंडिंग्स आई है, ये फाइंडिंग्स का कुछ बेस नहीं है।
that we have. Without it. Yes.
बाकी मैं रिफरेंस सबमिशन है, सबमिशन
Written submission.
हाँ, होगा। Item number 114, Mr.
Written submission होगी। चलते हैं।
हमारे बेस में इस केस से सिर्फ थोड़ा डिफरेंस है कि ये इंटरव्यू मैंने जो था रामलाल राइटर के बच्चे थे उनमें से कोई इंटरव्यू नहीं करता हमारा तो एलिगेशन ये भी नहीं है कि हमारे पैनल में कोई इंटरव्यू की इनमें से एलिगेशन
आप इसमें हैं
ये नोट्स आइटम नंबर वो 3 संगीत आ गया जो रामलाल राइटर के दो बच्चों का एलिगेशन था उनके इंटरव्यू में फेवर करने का एलिगेशन था उन दोनों में से कोई एक भी बच्चा हमारे इंटरव्यू पैनल में दिखाई दिया इंटरव्यू पैनल जो चेयरमैन कंटेस्ट करता है उसके अंदर कोई आई थिंक वो इंटरव्यू पैनल जो है उसके अंदर 5% होता है बच्चे और उसके अंदर 1 मेंबर का चेयरमैन और 2 सीनियर आईपीएस होते हैं जो पीजीटी जो राजस्थान है वो इसमें करते हैं और एक सब्जेक्ट का जो सब्जेक्ट से रिलेटेड जो होता है उसके अलावा एक साइकोलॉजिस्ट होता है में एक मेंबर है और हमारे जो इंटरव्यू पैनल है उसके अंदर ये दोनों कैंडिडेट अवेलेबल है उसके बावजूद ये हमारे इसमें कांटेक्ट करने का जो एलिगेशन है
आपकी तो ऑब्जर्वेशन है कि आपसे मिलने आए
ऑब्जर्वेशन ऐसे कोई कांटेक्ट किया वो भी
कांटेक्ट किया ना
फोन रिपोर्ट
तो कांटेक्ट तो इसलिए किया कि वो उनके किसी में भी आ सकते थे
हाँ वो आईपीएस मेंबर थे
तो आप भी मेंबर हो और क्या पता आपकी उसमें आ जाए ये तो पहले से पता होता नहीं है
तो पेज नंबर 162 इसके अंदर क्वेश्चन ये लाया है डिजिटल रामोरा नायका
पैरा 120 yes
third line in order to ascertain that Mustafa Raika secured good marks in the interview stage of the recruitment project with Raman Raika, chairman of RPSC Sanjay Savatya, other RPSC member including Bamlal Katara, Ruchi Sharma, Nandita Pragya, Jason Rati. During this meeting, Raika request his member to ensure his daughter got interview. Or 3-4 line notes since the RPSC chairman is responsible regarding the composition of the interview board for each candidate. Mr. Katara advised Ramuram Raika to first speak with RPSC chairman Sanjay Savatya. Mr. Raika met with chairman Savatya and subsequently informed Babular Katara according Shobha Raika interview was conducted before an interview board of which Babular Katara was part. चेयरमैन से मिलने के बाद में बाबूलाल कटारा उस इंटरव्यू का पार्ट था अगर हमारा अगर कोई कॉन्स्टिट्यूएंसी हो तो उससे रिलेटेड कुछ भी होता तो हम भी किसी न किसी पैनल में होते इसके अंदर एक पैनल में संगीता आएगा तो किसी भी उसमें नहीं है कि दोनों में दो बच्चे ऐसे बाबूलाल नायका के एक का नाम से डेविड आएगा
आपको कैसे पता रहेगा कि कौन से मेंबर या नहीं आए
इसमें एप्लीकेशन आया है वो आया कि चेयरमैन से मिले चेयरमैन ने इंटरव्यू चेयरमैन क्या आपको था इंटरव्यू पैनल में सो मेंबर कौन आएगा
you come to know who is who comes before you for interview you know the name
no
but you would know the face
no
obviously suppose if you have been shown that this person will come to you in your interview
ये एप्लीकेशन भी नहीं है हमारे को शो किया ये बाबूलाल कटारा को पिक्चर दिखाई थी
नहीं बाबूलाल कटारा ने दिखाई को बताइए ना
हाँ बाबूलाल कटारा को पिक्चर दिखाई थी बाबूलाल कटारा
नहीं रामू राय का हैज मेट यू ना
नो नोट्स एप्लीकेशन है ये और
ये कहां से आया है from where did this thing come that he came and met you
नोट्स ये कहेंगे बस सिंपल एप्लीकेशन सब पे इनसे मिला ये 5 लोगों से मिला चार्जशीट के अंदर ये तरह आया कि इन सबसे मिला बस इसके अलावा कहीं कोई डॉक्यूमेंट नहीं है कि इससे बात हुई हमारे को पूछा गया ना हमारे डॉक्यूमेंट्री एविडेंस में पूरे उसमें रिपोर्ट में है एसओजी की उसमें भी नहीं है कि हमारे उसके अंदर कोई इस तरीके का कोई एलिगेशन है
that's all
इसका शुरुआत हुआ आइटम नंबर 13 एंड मिस्टर पलाश हुआ आइटम नंबर 17
that's all
item number 17 and item number 13 Mr. Shivraj इसमें दिन के एक्टिविटी वगैरह
the arguments on behalf of the appellant is concluded आप किस पे
सर मैं आइटम नंबर 13 के अंदर अपीलांट नंबर 4
हाँ बोलिए आपका नाम
इससे संबंध में
आप अपीलान नंबर 4 कैसे हैं? आप पार्टी थे क्या नीचे?
हाँ सर,
हाँ?
हाँ सर, तो सिंगल बेंच का आदेश है, उसमें मैं पार्टी हूँ।
हाँ।
और सर इस
तो
पर्टिकुलर
अपीलान नंबर एक ही अपील तो होती है, सुन लिया ना अभी वो, इंडिविजुअली क्या सुनना फिर?
सर हमारा थोड़ा तो भी फैक्ट है सर।
आपका
They were in the waiting list.
मैं
They were in the waiting list of the sub inspector.
इस पर्टिकुलर करने की वजह से हमारे कौन राइट्स का वायलेशन हुआ है कि आरपीएससी ने जो भी हमारी न्यायालय की पूरी भी की कि आरपीएससी ने 3200 लोगों की नियुक्ति ने पीएचडी बेसिक करी, तो उसमें से 800 स्टूडेंट्स का सिलेक्शन करके उन्हें अंतिम चयन हेतु आरपी भेजा गया था। उसके बाद में सर अंजन बेंच के माध्यम से सेलेक्टेड करने के डायरेक्टली उनकी सीटें वैकेंट हो गई और कुछ इस दौरान बच्चे छोड़कर चले गए। तो हम सर तय समय में माननीय न्यायालय के समक्ष सिंगल बेंच के समक्ष हमारे याचिका की दायर करी, लेकिन उस दौरान जो सिंगल बेंच का जो आदेश है आने की वजह से सर हमारे को होल्ड हो गई, इसलिए माननीय न्यायालय को समक्ष कर दिया करना पड़ा। तो हम ये चाहते हैं कि इस मामले में जितने भी याचिका करता है सिंगल बेंच के समक्ष उन्हें नियुक्ति दी जाए और इस भर्ती को रद्द किया जाए।
इस भर्ती को
सब इंस्पेक्टर
क्या किया जाए?
रद्द नहीं किया जाए।
Item number 5 में horizontal to an application power in 100%.
और
That means the message भी आता है और इस group से power in 100 करते हैं, so you will put that.
इस वाले केस को
ये है
फाइनली करो।
हमारे सिग्नल
यस,
श्रीमान मैं
आप अपने वकील के थ्रू माध्यम से आइए, आपको पर्सनली नहीं सुनेंगे।
नहीं सर, मैं पावर ऑफ अटॉर्नी की जरिए सेल्फ करना चाह रहा था।
आपका पर्सनल क्या है?
सर मेरा पर्सनल तो ये है कि सब इंस्पेक्टर भर्ती के मामले में कुछ तथ्य है जो श्रीमान के पूरे नहीं बताए गए हैं, वो मैं बताना चाहता
आप
हूँ।
ये बताइए, आपका क्या लोकस है? आपने एग्जामिनेशन में पार्टिसिपेट किया था क्या?
जी श्रीमान, मैं सिलेक्टेड सब इंस्पेक्टर के तरफ से पावर ऑफ अटॉर्नी होल्डर के विषय से आया हूँ।
नहीं, आपको हम पावर ऑफ अटॉर्नी होल्डर को बहस नहीं करने देते। हमारे यहाँ पावर ऑफ अटॉर्नी वकील के पास होती है बहस करने की। अगर आपको ऐसे बहस करने की पावर ऑफ अटॉर्नी देने लग जाए तो फिर ये वकील लोग सब वकालत बंद कर देंगे।
श्रीमान मेरा
तो कोई भी देना पावर ऑफ अटॉर्नी लेके बहस करना शुरू कर देगा हाई कोर्ट में। वी विल नॉट अलाउ, रिजेक्ट। लिखिए, an application has been filed by one power of attorney holder on behalf of some candidates seeking impeachment. He is neither a lawyer nor a participant. Power of attorney as provided under the provisions of law is only for to sue and not to argue. Arguments can only be advanced by an attorney holder. Attorney means the lawyer. The application is therefore rejected on behalf of such a power of attorney holder. Likhiye, arguments have been heard on behalf of the applicant, of the appellants at length.
Sir,
one day the accommodation manner discussing is not well mannered, only for one day the accommodation may be kept on 15 minutes.
Will the case be again listed on 15th
15, great.
at 2?
Service वगैरह से जितना
Grateful lot.
We'll pass orders on that. अब आज तुम सुबह अर्जेंट करे थे ना, हमने सुने थे अर्जेंट। आप आते तो अर्जेंट सुन लेते, 19 तारीख 19